All right, let's take you to this now. Australia is set to become the first country to implement a minimum age for social media use on Wednesday, with platforms like Instagram, TikTok and YouTube forced to block more than 1 million accounts, marking the beginning of an expected global wave of regulation. From midnight, 10 of the biggest platforms will be required to block Australians aged under 16 or be fined up to $33 million. That's roughly over 560 million rands, just for context. Now, the law received a harsh criticism from major technology companies and free speech advocates, but was praised by parents and child advocates. To speak more on this, let's now welcome John Makate, Associate at Rupert Candy Attorneys. Sir, thank you so much for your time. A very good afternoon to you. So this move has been praised by many and described as an unprecedented step by some. Just help us understand then the legal grounds Australia relied on here. And more importantly, how will compliance by the companies be monitored, just given the stringent regulation and, of course, the penalties?
Good day, ma'am, and good day to your viewers. To sum it up, the policy emerged from extensive consultations, including input from youth groups, parents, digital industry stakeholders, civil society, child development experts, mental health professionals, policymakers, and of course, lawyers. And the ban itself is promulgated by Australia's Online Safety Act, which makes provision for an e-safety commissioner, right? Which comes to the second leg of your question. The e-safety commissioner plays a vital role in the compliance as they enforce compliance with the act itself by approaching the platforms and providing them with the responsibility to ensure age accuracy, account handling, and reporting transparently to the Australian government the age of all Australian users to ensure that no one under the age of 16 has an account.
So let's talk about the companies here that, will be affected. Could these major technology companies, could they challenge this ban in court? And, on the grounds, as they've already said, of free speech, what legal arguments do you think might they raise, especially as they are already accused of preserving their own business models, not concerned about the long-term dangers of social media on children, as we've been seeing in numerous countries?
Yeah, so major technology companies could potentially challenge this ban, of course, and their primary argument would be that it infringes on free speech rights or exceeds government's regulatory authority. Legally, they might even assert that such a ban constitutes an undue restriction on freedom of expression, particularly where social media nowadays, as we've seen, serves as a platform for communication, expressing views, education, and civil engagements. However, just as the state is in South Africa, these rights have a limit, and particularly including but not limited to the right to freedom of expression. It's not absolute. It must be weighed against what is in the best interest of those who are under 16 in this context. And the justification by the Australian government would obviously supersede that argument more often than not, as it would be that social media has a negative effect on those under 16, which means that the ban is in the best interest of the child. But however, it's not a set in stone case. Courts would likely weigh these claims against one another, and depending on the veracity of the allegations and the facts which that social media platform brings to the matter.
And I mean, there's so many questions just around legal precedent. What precedent does this ban by Australia then set for other countries when you consider, of course, that South Africa has raised similar concerns of age-based social media restrictions, especially as it speaks to privacy and data collection. But thank you so much, John, for your time this afternoon. Really do appreciate it. Just commenting there from a legal perspective. John Makate, Associate at Rupert Candy Attorneys.